Hello. Welcome to my channel. Right here on YouTube. My name is Shirley, and my channel name is Shirley's Channel Chatter, and I have 4 channels here on YouTube. I just started. Well, one channel I had about a year ago, and the other 3 I just started. So I just, something to do. So just in the process of building all my content. So I have a little bit of law, a little bit of business, a little bit of accounting, talking about ancient philosophers. I'll probably talk about a whole lot on my channel, but my channel is going to be geared toward education, educational, inspirational, enlightening, no gossip. So I might have some, current events, current legal issues in the news, current videos, so that I'll probably have some of those on my channel, which I already have on my channel now, but just trying to keep up with the current situations in a lot of cases around the world. So I'll be bringing light to some of those. I might, discuss some of them, and who knows, I might have some interviews on my channel. But so let me get started. It's okay. On my previous channel, I did shed light on some ladies and gentlemen, that we, always talk about when Black History Month comes around, year after year. So, Rosa Parks, Frederick Douglass, Martin Luther King, so many, Francis Scott Keys, and another lady called, her name is, so Rosa Parks, she was cited for not wanting to give up her seat on the bus in Montgomery, Alabama. So she didn't want to give up her seat. She had just got off work, and so she had just gotten off work, and she didn't want to give up her seat. But she, according to my readings, she said it wasn't just because she was tired. It was because she was tired. She was tired of going through the situation over and over again, where they would get on the bus and then the white passengers didn't have a seat, and so the black passengers, they were supposed to go back to the back of the bus. But she paid her fare, she sat down, and she was like, I'm tired, and I'm tired of this mess, because, I paid my fare, and I'm tired of this mess, I want to sit down. So she got arrested, and went all the way to the Supreme Court, and then they made it, then the judge issued a ban on segregation when it came to their bus company. So they could no longer separate white passengers from black passengers, and when the black were African American, I like to say African American, so when African Americans got on the bus and they paid their fare, they could sit down. So, and then there's a few other ladies. I know one I want to shed light on. Her name was Miss Claudette Clover. Yeah, Claudette Clover. And they said, I think it was 6 months. I think it was 6 months. I know I did it, so it's in my research. I think it was 6 months before Rosa Parks' situation. So Rosa Parks was affiliated with the NAACP, and so that's why they shed more light on her situation than Miss Claudette's. But Miss Claudette is still alive today. But just want to go over a few law terms first before I step into the Black History honorees, I guess. Black History Month honorees, I would call them. So the first term I want to talk about is the broken windows theory. So the broken windows theory, so like I said, that comes into play when officers, law enforcement, they want to clear those small crimes up before they lead to larger crimes. So in other words, just an example, if you, small crimes, say for instance you've been cited for smoking a little bit of marijuana, or you run a stop sign, something small, they want to make sure they give the proper punishment, I guess I would say, proper punishment for that, you know, that small crime. That way it won't lead, then that same person won't go back out there and commit a bigger crime. If that, in other words, if the small crime go unpunished, then those people that commit those small crimes may then go out there and commit a larger crime. So in other words, so it reminds me of B.F. Skinner and Pavlov. I studied those two gentlemen too down Australian University. So B.F. Skinner, he dealt with operant conditioning, where he talks about you know, if you commit a crime, or if you, well, he wasn't talking about committing a crime, but he was talking about punishment. In other words, if you do something, in other words, it has to be a consequence. So in other words, you commit a crime, I'm just using a crime as an example, but in other words, he's talking about punishment. So he's talking about if you know, what if you do something, but there's no consequence behind what you did? What would the likelihood of you, you know, doing that, repeating that again, if there was no punishment or no consequence? In other words, and also it doesn't have to be a bad. It doesn't have to be a bad act that you committed. It could be, in other words, if your mother say, "Hey, go to the store for me, and I'll give you $20." Your mom said, "Go to the store for me," a friend of yours or whomever said, "Go to the store for me, I'll give you $20. So what is the likelihood of you, you know, if they ask you again, would you go to the store for them? Naturally, because they gave you $20 the first time, so you assume that, hey, every time I go to the store for them, I'm going to get that $20. You'll be conditioned to know that when you go to the store, that you're going to get that $20. So we talk about B.F. Skinner and Alvin Pavlov. So B.F. Skinner, you can, you know, you can do more research on him and find out, you know, more of what he, you know, what he meant when he talked about operant conditioning. So B.F. Skinner and Alvin Pavlov. So let me go to the broken windows theory. So the broken windows theory, when law enforcement, they don't want those smaller crimes to lead to larger crimes. So let me see exactly, that's my definition of it. Let me explain. Let me explain from the, you know, internet's definition. So broken windows, the broken windows theory, they have the broken windows theory, broken windows theory criminology, broken windows theory in policing. So I'm going to go with the broken windows theory in policing. So the broken windows theory in policing, it says that has failed. But a lot of people don't really like that type of policing. They don't like that type of policing because it's almost like nitpicking on such small things, like and I mean, you know, like somebody have a couple crumbs, you know, something, you know, a couple crumbs of marijuana, just a couple crumbs. I mean, I know the laws have changed, but you have a couple crumbs and they catch you with that, then they, you know, I know some people that had to go to court for like 6 or 7 months for just having a little bit on them. You know, I don't deal with none of that, don't smoke no marijuana, but I have heard of people that, you know, had to go. But now, since the laws have changed, that was before the law changed. So in other words, that's just an example of a small crime. You have a couple little crumbs of marijuana, and then you have to, you know, you go to court for 6, 7 months. But that's like a smaller crime that they don't want to lead. They don't want to have nothing like that lead to a larger crime. So that's what the idea of. That's why a lot of people don't really like the broken windows theory. So it says one of the most successful ideological movements waged by government agencies in recent decades has been the so-called broken windows theory in policing, popularized in the 1980s by George Kelly. The theory states that if minor violations are ignored, as I was saying, such as the breaking of a window on private property, but I use marijuana as an example, then those small infractions will act as a signal to others in the community that more serious crimes can be committed with impunity. That's what I'm saying, see. In other words, they say, right, you go break somebody's window, somebody's car window, that's something small. But sometimes those smaller crimes can have large penalties, you know, but they just trying to wean those smaller crimes out so they won't lead to a larger crime. That's why they said here, it says it was popularized in the 1980s by George Kelly. The theory states that if minor violations are ignored, in other words, if they ignore minor violations, they can lead to larger crimes. If minor violations are ignored, such as the breaking of a window on private property, then those small infractions will act as a signal to others in the community that more serious crimes can be committed with impunity. So in other words, if the smaller crimes are not taken care of at the same time, they may feel that law enforcement is not on their job. So well, we can go out there and commit a larger crime because they didn't do nothing to us for the smaller crime. So we broke somebody's window, we flattened some tires around in the area, and nothing didn't happen to us. There were no consequences. Like B.F. Skinner, he said there must be a consequence for action. Definitely should be a bad consequence for a bad action. So let me read further. In political and policing circles, this theory became immensely popular during the 1990s and persists today, although repeated demonstrations of the forceful and deadly methods used by police to address small-time infractions has prompted many to ask if coming down hard on every little thing is really the best way to police a neighborhood. That's what I was saying. Coming down hard on these little small infractions, small crimes, coming down hard on them, you know, just to make sure that, you know, that they don't then go back and, you know, but there has to be a consequence at the same time for your actions. It says, while Kelly successfully reinvigorated the idea, the broken windows theory in the 1980s was not new or novel. It was simply the latest manifestation of what has also been termed community policing and order maintenance policing. At their core, these ideas taken together depend on the idea that policing interactions with community members should be expanded well beyond criminal activities while giving police officers more discretion over what laws to enforce and when. Two views, community policing versus limited policing. Community policing and order maintenance policing have long been in tension with competing views of policing, in which the police should be more limited in their role and focus more on serious and violent crime. So I'm not going to read too much more of that. So let's go to, and I want to read something real quick. I want to talk about the first police force. So I studied a little bit about that too. The first police force, they didn't even have, back then they didn't even have weapons. They didn't have no weapons. The first police force, let me type it in. So just wanted to touch base on that. So I don't know if anybody know anything about that, okay. So the first police force was started by a gentleman named Sir Robert Peel. Sir Robert Peel popularly credited with, he was popularly credited with the formation of the first modern municipal police force, founded in London in 1829. Before him, what passed for policing was really a hodgepodge part-time volunteers, night watches, thief takers, commissioned to hunt for criminals, and other iterations of private fee-based security. So the first police force, history of the first police force. Sir Robert Peel. So, said how the U.S. got its police force. So let me show you what they look like. This is what they look like back in the day. The first police force. So that's what the first police force looked like. So, the first police force, it says, it would be easy to think that the police officer is a figure who has existed since the beginning of civilization. That's the idea on display in the proclamation from President John F. Kennedy on the dedication of the week, May 15th, as National Police Week, in which he noted that law enforcement officers had been protecting Americans since the nation's birth. It says, in fact, the U.S. police force is a relatively modern invention sparked by changing notions of public order driven in turn by economics and politics, according to Gary Potter, a crime historian at Eastern Kennedy University. So I don't want to read a whole lot. Let me see. I thought this was going to go into, let me go back to, I don't know what that page. Sometimes these pop-ups come right up on my computer. The first police force in America. So that's what they look like. They didn't have any weapons. So, well, I know they're not going to go back to that type of policing. It says the history of policing. Let me see, I'm trying to find oldest police department. Let me type in his name, Sir Robert Peel. Sir Robert Peel was credited for starting the first police force. Sir Robert Peel, they say he was former Prime Minister of the United Kingdom. Okay, Sir Robert Peel. This is what he looked like. Sir Robert Peel. It says Sir Robert Peel, 1829, he established the London Metropolitan Police Force. He became known as the father of modern policing, and his commissioners established a list of policing principles that remain as crucial and urgent today as they were 2 centuries ago. So they don't have a lot of writings on here, but they do have Robert Peel. He was born February the 5th, 1788, July the 2nd, 1850. Let me click right here. I can click and say the history of Sir Robert Peel. It said Robert Peel, he was born February the 5th, 1788, in Lancaster. His father was a wealthy cotton mill owner, and Peel was educated at Harrow and Oxford, entering Parliament as a Tory in 1809. His early political career included appointments as Under Secretary for War and Colonies and Chief Secretary of Ireland. I'm not going to read a whole lot of this. It says in 1841, Peel again formed a conservative administration, and it was during the government that he oversaw the introduction of significant legislation such as the Mines Act of 1842. So he was credited for starting the first police force. And back then they didn't have any weapons like they do now. So they just had like their long sticks. And that's what they had. They didn't have no, but, and so this is just telling all about how he, how he started out working, in government and his parents and different things. Let me see if I can find something else out about him. So Sir Robert Peel, it says Sir Robert Peel's policing principles to prevent crime and disorder as an alternative, to recognize always the power of the police, to recognize always that to secure and maintain, to recognize always that the extent to which, so it says I don't want to click on that, they call it the Peelian principles. It summarizes the ideas that Sir Robert Peel developed to define an ethical police force. The approach expressed in these principles is commonly known as policing by consent. So you can read up more. And they called the first police force, they were called the Bobbies. So this look like him right here, Sir Robert Peel. Hold up, let me see. Sir Robert Peel, this is what he looked like. So that's Sir Robert Peel. He started the first police force called the Bobbies. They didn't have any weapons, they just had their little sticks. I don't know if they called them batons or whatnot, but so that was Sir Robert Peel. And so when I was reading about the broken windows theory, I just thought about that. I said, I don't know if anybody know about the first police force where they didn't have any weapons. Well, anything can be used as a weapon when it comes to policing. So anything can be used as a weapon, but they didn't have no arms, But so anything can be used as a weapon. You put that force behind it, put that intent behind it, because most crimes are built on intent. Some of them are not, like negligence. In Britain today, all policemen are commonly referred to as Bobbies. Originally, though, they were known as Peelers. So Sir Robert Peel, they called them the Peelers, they called them Bobbies. 1788 to 1850. Today it's hard to believe that Britain in the 18th century did not have a professional police force. Scotland had established a number of police forces following the introduction to the city of Glasgow. Okay, I'm not going to read too much of that. Let me go to another term called habeas corpus. So let me go to habeas corpus. I'm not going to make the video too long. Let's go to habeas corpus. Let's see what habeas corpus means. And then we got the standard of proof. We have de facto, we have a grand jury, litigation, pro se. Habeas corpus is a recourse in law through which a person can report an unlawful detention or imprisonment to a court and request that the court order the custodian of the person, usually a prison official, to bring the prisoner to court to determine whether the detention is lawful. So they say click on for more. So habeas corpus is through which a person can report an unlawful detention. So in other words, if somebody is in prison and they feel that they are in prison unlawfully, because it says unlawful detention or imprisonment. So you in court, they say you report it to a court, I guess. But in other words, if you are in prison unlawfully, you are unlawfully detained in prison, and so that's where you can have your lawyer file this habeas corpus. And so it says unlawful detention or imprisonment to a court and request you can report it to a court and request that the court order the custodian of the person, usually a prison official, to bring the prisoner to court to determine whether detention is lawful. So they want to see if the detention is lawful. In other words, you think you're falsely detained and you want to report that, you know, I guess you'll report that to your lawyer, and then they'll bring you to court. So I guess the judge would then find out if the prisoner, if you are unlawfully detained. So that's the habeas corpus. Then they had a writ of habeas corpus described in the 18th century by William Blackstone as a great and efficacious writ in all manner or illegal confinement. It is a summons with the force of a court order. It is addressed to the custodian and demands that the prisoner be brought before the court and that the custodian present proof of authority, allowing the court to determine whether the custodian has lawful authority to detain the prisoner. So they want to find out whether they have, you know, whether they can lawfully detain the prisoner. So it said it demands that the prisoner be brought before the court. So the writ of habeas corpus was described in the 18th century. It is a summons. So in other words, a summons for the prisoner to come to court, so that way they can be in court. They can determine whether or not they are being held illegally, or they can be held, are they being held lawfully? You know, because sometimes people can hold you, you know, you held up in court, you held up in jail when you're supposed to have been out. You're supposed to have been out. So let's go to, so habeas corpus, you can look more, you can look that up and you can find out more information. You got the broken windows theory, so that's a good theory to look up. Habeas corpus, let's go for the standard of proof. So I know the standard of proof in criminal cases is beyond a reasonable doubt. And then civil is preponderance of the evidence lies within the plaintiff. So let me make sure let me make sure what I'm saying is right. Let's go for the standard of proof. I know my friends were like, Miss Cheryl, you think you a lawyer? I said, no, not really. Okay, the standard of proof refers to the duty of the person responsible for proving the case. Right, yep. Standard of proof is the person responsible for proving. So in other words, in civil law, tort law, where you get money damages for civil, tort law, civil law, is the preponderance of the evidence lies within the plaintiff. But in criminal law, is the burden of proof falls on the government. So that's the criminal law. So it said there are different standards of proof in different circumstances. The three primary standards of proof are proof beyond a reasonable doubt, preponderance, as I said, of the evidence, and clear and convincing evidence. So standard of proof, you can read more up into that. Let's look for de facto and see what that is. De facto. I heard that term before, but D-E-F-A-C. De facto, and let's see, de facto, in fact, it says in fact, no, in fact or in effect, whether by right or not, often contrasted with de jure. De facto, let's see, it says, what does de facto stand for? Let me click on that one. The term de facto translates to mean in fact in the world of law, and if something is de facto, that means it exists in fact, even if not legally recognized. For example, de facto corporations may have failed to file all the necessary paperwork to be legally recognized as corporations, yet have behaved in such a way as to be considered corporations in fact. So in other words, de facto means they're saying it's basically it's fact, but it's not legally recognized, but it's still fact. In other words, you running a corporation, but you know you are a corporation, but you have, look like you would have the paperwork you have to have the paperwork your articles of incorporation to say that you are a corporation. Like I said, the term de facto translates to mean in fact. So in other words, you're operating under the assumption that you are a corporation. Because if something is de facto, that means it exists in fact, even if not legally recognized. For example, de facto corporations may have failed to file all necessary paperwork to be legally recognized. Okay, I'm just saying. In other words, you're running a corporation, but you're going about your everyday business, running your corporation. Say, for instance, you producing products, you're selling, you're marketing this, advertising, promoting this brand, your brand and your products, but you have not legally filed your papers. But you're doing normal business. You're operating as a corporation. So that's what they're saying, de facto, mere fact. But they have, in other words, for example, de facto corporations may have failed to file all the necessary paperwork to be legally recognized as corporations. So that's de facto. You can look more, you can, do some more research on that term too if you want to. So let's go to grand jury. So I want to say thanks for joining me today, and hope you will subscribe to my channel. Let me look up grand jury. So subscribe to my channel. Comment below if you have any topics you may want me to do some research on, talk about. I would love to do some interviews right here. I'll see what I can do on my channel. I'm up for stepping out the box. I'm up for a lot of, different ideas. But the grand jury is a group of citizens empowered by law to conduct legal proceedings, investigate potential criminal conduct, and determine whether criminal charges should be brought. A grand jury may subpoena physical evidence or a person to testify. A grand jury is separate from the courts, which do not. A grand jury may subpoena physical evidence or a person to testify. A grand jury is separate from the courts, which do not preside over its functioning. So a grand jury is a group of citizens empowered by law to conduct legal proceedings, investigate potential criminal conduct, and determine whether criminal charges should be brought. So in other words, a grand jury, somebody, when you're looking at movies, you see how they say, we initiated a grand jury. So it's a group of citizens empowered by law to conduct legal proceedings. So they conduct their legal proceedings, they investigate the potential criminal conduct, and they want to see whether that charges should be brought. So now I served on the petite jury. That's why they call it the petite jury, I guess, because we don't do no investigating. We just look the evidence over, sit in the jury room, deliberate, go over the evidence, and then decide whether they're guilty, not guilty, or guilty. So that's grand jury. So let's look up next term, litigation. So litigation means lawsuits. But let me see what else they saying about litigation. Litigation, they got lawsuit. So litigation, a lawsuit is a proceeding by one or more parties against one or more parties, against one or more parties. It say lawsuit, but let me see, it says, L-I-T-I, litigation. When I type in litigation, it came up with lawsuit. Okay, when I typed in litigation, it came up lawsuit, but let me click on what is a litigation. So litigation is basically lawsuits, but they're not giving me. So what is a What is a litigation? So, litigations, I assume they are lawsuits. They got settlement litigation with a trial, particularly where a trial by jury is available. Generally, one side or the other will make a settlement offer early in litigation. When you have litigation, it refers to a special federal legal procedure designed to speed the process of handling complex cases such as air, disaster litigation. So all kinds of litigation. Sometimes companies have litigation issues. People can have a litigation issue, a lawsuit. You can have somebody can, try to sue you for malpractice. Doctors get malpractice litigation all the time. All kinds of lawsuits can, come about. So you might want to sue a company because you purchased something and it didn't satisfy your need. So whenever you want to have a lawsuit, companies sue each other all the time. Civilians, they get sued. They may have a lawsuit against somebody. You could be in a car accident, or you can get sued, that way as well. But usually the insurance, if you have insurance, they take care of the claims. Well, they take care because you have your personal injury protection when it comes to your car insurance policy. So litigation, you can look up that. Term too. So let's go look at pro se and see what that means. This is a term. I heard the term before, but wasn't quite sure what it meant. P-R-O-S-E. Let me see. Pro se legal representation in the United States. Pro se legal representation. It says pro se comes from the Latin word meaning for oneself. So pro se meaning for oneself or on behalf of themselves, which in modern law means to argue on one's own behalf. I know I heard of per se, but I never heard of pro se. So in other words, on one's own behalf, legal proceeding as a defendant or plaintiff in civil cases, or a defendant in criminal cases rather than have representation from counsel or an attorney. So that's the status is sometimes known as impropria persona. Then they have abbreviated to pro per. That's like a different term. Okay, so that's pro se. So in other words, for oneself, it says for oneself, comes from Latin. It's a Latin term, pro se, meaning for oneself. Let's look up warrant. Warrant. So let's look up a warrant, search warrants. So warrant, it's a warrant, a form of specific authorization. You may have arrest warrant, search warrant, execution warrant. They have a warrant, a proper justification for holding a belief. Warrant, then they have the assumption of principle that connects data to a claim. And quo warranto, never heard this term before. Quo warranto. Look like quo warranto, a writ requiring a person to show authority for exercising some right or power. So let's look up search warrant. It just say warrant. Search warrant, court order that a magistrate or judge issues to authorize law enforcement. So it's a court order from the judge that authorizes law enforcement officers to conduct a search of a person, location, or vehicle for evidence of a crime, and to confiscate any evidence they find. In most countries, a search warrant cannot be issued in aid of civil process. So in other words, civil cases, they don't do search warrants and all that in the civil, but search warrants probably will come under criminal law. And then it says jurisdictions that respect the rule of law and the right to privacy constrain police powers and typically require search warrants or an equivalent procedure for searches police conducted in the course of a criminal investigation. The laws usually make an exception for hot pursuit. A police officer following a criminal who has fled the scene of a crime has the right to enter a property where the criminal has sought shelter. The necessity for a search warrant and its abilities vary from country to country. In certain authoritarian nations, police officers may be allowed to search individuals and property without having to obtain a court permission or provide justification for their actions. See, the necessity for a search warrant and its abilities vary from country to country. So, right, they're saying sometimes they may not need a search warrant. So, in other words, if they in hot pursuit and they got a lead on the criminal, but they chasing him, and they don't have time, they're not going to stop and try to get no search warrant while they, you know, in other words, they have a suspect, and I guess they had a suspicion that he may have robbed the store or, you know, committed a crime, but they in pursuit after the suspect. They're not going to call the judge and try to say, hey, well, let's get a search warrant. You know, nah, they're going to try to apprehend him or her. See, the laws usually make an exception for hot pursuit. That means they're in route, hot pursuit. A police officer following a criminal who has fled the scene, right? He fled the scene, and fled the scene of a crime has the right to enter a property where the criminal has sought shelter. So in other words, the criminal fled the scene of a crime, and the police, you know, law enforcement, they are in hot pursuit behind him, and him or her, and they go into somewhere and seek shelter, so the police is going to go right behind them. They're not going to take time to get no search warrant. So that is a warrant. So let's go to a gentleman name I learned about. I think I spelled it wrong, or. Okay, since I'm talking about search warrant, I want to talk. I typed it wrong though. Let's talk about the Miranda warning. Okay, in the United States, the Miranda warning is a type of notification customarily given by police to criminal suspects in police custody, advising them of their right to remain silent, the right to silence, and in effect, protection from self-incrimination that comes under the Fifth Amendment. That is their right to refuse to answer questions or provide information to law enforcement or other officials. These rights are often referred to as Miranda rights. So I learned about a gentleman named Ernesto Miranda. Well, he was arrested for, I think he stole something. He stole something out of the store. He committed a crime, but they didn't read him his rights. His name was Ernesto Miranda. So I think it was back in 1963 or something like that. I could be wrong, but they didn't read him his rights, so his name was Ernesto Miranda. That's where they got the Miranda rights from. So it said these rights are often referred to as Miranda rights. The purpose of such notification is to preserve the admissibility of their statements made during custodial interrogation and later criminal proceedings. The idea came from law professor Yale Commissar, who subsequently was dubbed the father of Miranda. The language used in the Miranda warning was derived from the 1966 U.S., there it is right here, 1966 U.S. Supreme Court case Miranda versus Arizona. The specific language used in the warning varies between jurisdictions, but the warning is deemed adequate as long as the defendant's rights are properly disclosed, such that any waiver of those rights by the defendant is knowing, voluntary, and intelligent. So in other words, if you volunteer to confess, then the law enforcement does not have to read you your rights. They don't have to read you your rights because you're confessing. They are not going to stop and read the Miranda rights. So, so it says the specific language used in the warning varies between jurisdictions, but the warning is deemed adequate as long as the defendant's rights are properly disclosed. In other words, you can, they have to make sure that your rights are not being, violated. It says you have the right to remain silent. Anything you say it says anything you say can be used against you in court. You have the right to talk to a lawyer for advice before we ask you any questions. So this is a long one. You have the right to have a lawyer with you during questioning. You cannot afford a lawyer. One will be appointed for you before any questioning if you wish. If you decide to answer questions now without a lawyer present, you have the right to stop answering at any time. So in other words, if you get to talking, you don't have no lawyer, you have a right to stop at any time. So why start? Just wait for your lawyer. The Miranda warning is part of a preventive criminal procedure rule that law enforcement are required to administer to protect an individual who is in custody and subject to direct questioning or its functional equivalent from a violation of their Fifth Amendment. Like I said, the Fifth Amendment, fear of self-incrimination. And it says that's why a lot of times when defendants stay on trial, the lawyer don't want them to testify against themselves for fear, the Fifth Amendment, invoke your Fifth Amendment right. I don't want to, testify, incriminate myself for fear of self-incrimination. Fifth Amendment. In Miranda versus Arizona, the Supreme Court held that the admission of an elicited incriminating statement by a suspect not informed of those rights violates the Fifth Amendment and the Sixth Amendment right to counsel through the incorporation of these rights into state law. Thus, if law enforcement officials decline to offer a Miranda warning to an individual in their custody, they may interrogate that person and act upon the knowledge gained, but may not ordinarily use that person's statements as evidence against them in a criminal trial. So, and further down it said the concept of Miranda rights was enshrined in U.S. law following 1966 Miranda versus Arizona Supreme Court decision, which found that the Fifth and Sixth Amendment rights of Ernesto Miranda, he had been violated during his arrest and trial for armed robbery, kidnapping, and rape of a young woman. He was subsequently retried and convicted based primarily on his estranged ex-partner. So eventually he committed another crime, and eventually he was arrested again, because it says he was subsequently retried and convicted based primarily on his estranged ex-partner, so who had been tracked down by the original arresting officer via Miranda's own parents, suddenly claiming that Miranda had confessed to her when she had visited him in jail. Miranda's lawyer later confessed that he goofed the case by focusing too much on the constitutional issues and losing sight of the jury and guilt or innocence. So in other words, initially they violated him during the arrest, and they didn't read him his rights. So that's how they named it the Miranda rights. So you can read more on Ernesto, his middle name is Arturo Miranda. So that's where he got the Miranda rights from. And then we have, let's talk about the, we have a couple of other words. I think I looked up writ. Let's touch base on that real quick. So writ, and then I have acquittal. So in common law, a writ is a formal order issued by a body with administrative or judicial jurisdiction. In modern usage, this body is generally a court. So a writ is a formal written order from the court. Formal written order from the court with administrative judicial jurisdiction. In modern usage, this body is generally a court. Warrants prerogative writs, subpoenas, certiorari are common types of writ, but many forms exist and have existed. So I'll probably get into some more different types of writs since I just found this out. In its earliest form, a writ was simply a written order made by the English monarch to a specified person to undertake a specified action. For example, in the feudal era, a military summons by the king to one of his tenants-in-chief to appear dressed for battle with retinue at a certain place and time. So in other words, a writ, a formal written order from the judge, from the court. So in other words, you get a formal, you get a writ, well, you know, it comes in the form of a subpoena, warrant, certiorari. In other words, it's a formal written order issued by a body with administrative or judicial jurisdiction. So that's the court's jurisdiction. In modern usage, this body is generally a court. So it could be a warrant, it could be a prerogative writ, a subpoena, or certiorari. So in other words, you get those, any one of those, you definitely have to appear in court. Just like when they call you for jury duty, that's almost like one right there, because if they call you, you got to go. Unless you have, doctor's excuse. So the writ was a unique development of the Anglo-Saxon monarchy and consisted of a brief administrative order. So back in the day, so they've been issuing writs since way back in history. So I'm not going to read too much more of that. Let's look at the, let's see what other term I have, the acquittal. Let's look up acquittal. Let me go back to acquittal later. Let me go with noli prosecute. So I think this is when they voted, do away with the charges. NOELLEPROSECUTE.